My name's Duncan and I work in the planning team at Scown. Judicial review is a term much used in the media, but not often well understood. In this video, we'll explore the role of judicial review in a planning context. And when we use that term, we are also referring to planning statutory challenges, since they share many attributes. At its most basic, judicial review is the process by which the courts provide oversight of the lawfulness and fairness of the decisions of public authorities. For our purposes, we're talking about the planning court, reviewing the decisions of local planning authorities and the planning inspectorate. The important thing to remember, whether you are seeking to bring a challenge or your decision is subject to a challenge, is that a successful judicial review does not reverse the original decision. It merely cancels it. The planning application or planning appeal then goes back to the council or the planning inspectorate as appropriate and will then go back through the decision-making process. Not everyone can bring a claim. There are parties with obvious standing: the applicant in a planning or enforcement appeal, the local planning authority, and the planning inspectorate. An objector to a planning application that is subsequently granted may be allowed to bring a challenge. Protest groups have also been allowed to be the claimant where the issue is one of public importance that wouldn't otherwise be raised. The planning system is often accused of holding up development, particularly the delivery of housing. One logjam that was identified was the practice by developers of waiting for 3 months following the grant of planning permission before they would buy the land or start development. The reason for this was that the grant of planning permission remained vulnerable to a judicial review challenge for that period. In contrast, a successful planning appeal decision was only vulnerable to challenge for a period of 42 days. Those two regimes, with some subtle differences, have now been aligned, and the time for challenging a grant of planning permission or a decision following a planning appeal is now 42 days. That's just 6 weeks. One notable exception to this rule is for enforcement appeal decisions. These must be challenged within 28 days of the date of the decision. Although for enforcement appeal cases, the court does have a power to extend the time within which a challenge must be made, even if that application to extend the time has been made after the time for compliance has expired. This is, however, a discretionary power, and every effort should be expended in identifying the deadline and working to it. It is now the case that whether by judicial review or statutory challenge, the permission of the court is required to bring the challenge. In reality, this is now built into the process. All claims are considered by a High Court judge, generally based on the papers submitted and without a hearing taking place, as to whether the case is arguable. That is not a predetermination of the outcome. The court isn't saying that the claimant will win, merely that its case has sufficient merit to proceed to a full hearing before a judge. Tactically, it may be that a defendant counsel will hold out to see if permission is refused. If not, it may seek to negotiate a settlement rather than have the matter go to a full hearing. Again, this can't be relied on in all cases, but may be a possibility in some. The grounds on which a challenge can be brought are constantly being updated by decisions of the court itself. However, in broad terms, to be successful in a challenge, a claimant must convince the court that the council's or planning inspector's decision falls within one of the following 4 categories: that it was illegal. In other words, that it got the law wrong. It exercised a power that it had but wrongly, or it exercised a power that it never had in the first place. Irrational, where it took into account immaterial considerations or failed to take into account material considerations, or where its decision was so unreasonable that no reasonable decision maker could ever have come to it. Procedurally unfair. For example, a statutory procedure wasn't followed, or there was bias, or an affected party was unfairly prevented from making their representation. Legitimate expectation. Such challenges are rare, but may occur where a council, for example, has said specifically that it will act in a particular way in making a decision, but then does not, and a party is prejudiced as a result. The two most common remedies sought in judicial review are an order quashing or cancelling the decision being complained about, and of course an order for costs to be awarded in favour of the successful party. I hope this has been useful. If you'd like to know more or discuss any of the points raised, then please do get in touch.